Buckle up, guys. Today we are going to dive into some of the most absurd, chaotic, and fascinating courtroom moments featuring sovereign citizens across 4 states. Get ready for unpredictability, legal chaos, and judges showing the ultimate patience and control.
Good afternoon, Your Honor. Don Silva on behalf of the people, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself and state your name for the record.
Okay, I got it.
You got it.
All right, you hear me?
Yep.
All right. So this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness. At the time, he would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with trial to see if there's a resolution.
All right. And Mr. Darren.
I mean, Your Honor, I guess we're gonna proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated, I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over, at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while.
Personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family
First,
home.
I want to deal with the whole bond thing.
Yes.
His bond is $2,500 personally.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother Counsel appeared for the first time on this case, I agree, and that's when
Eric Martin's courtroom entrance sets the tone for chaos. His inability to respect no-contact orders immediately puts him at risk, creating tension as the judge carefully explains bond conditions. You can feel the suspense rising as Eric debates his rights, showing how defiance clashes with legal reality. This is a masterclass in patience from the court and a preview of trouble to come.
the bond was changed, but Mr. Martin,
Judge Kirsten.
yes.
So, Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to.
I mean, I have no objection.
Mr. Martin, now listen, you understand? I wasn't here, but Judge Kirsten, the original bond was $2,500 personal. Then he set it at $2,000 cash because of the alleged violation. That says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything on whether there's an alleged violation of the bond condition. Is that right?
Not an alleged violation. He made comments.
He made a comment about it.
That he'll return back to the house.
This is why something. All right. So you understand you can't go to that house while you're on that. That's while the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand, and I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected. No, listen, let me talk. I objected to the bond conditions before, I'm objecting to them now under due.
Listen, your objection is duly noted. You have very, very highly competent counsel. So, let's let your counsel speak on your behalf. And so he already did. He made a motion.
Well, Judge, he's speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days, and then you can just sit there anyway for it. Stop interrupting. Mr. Darren made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. No contact with the victim or the victim's home location. If you show up at that location and violate my bond, you could be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal. No contact with the victim.
Here, the judge finally sets Eric's bond at $2,500 with
I already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
We'll see everybody at trial.
I have something to say in response.
We'll see everybody at trial. Mr.
Your Honor,
Darren, do you have any-
response.
Mr. Darren, do you have anything else further?
Your Honor, are we going to set it for a settlement conference, or are we just going to set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right. Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't. But if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have an. I mean, I'm not going to. I'm advising him not to say anything. But Mr. Martin, if the judge wants to hear it, if he's allowing it, then I'll step aside and let you stay.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea if you just do so. But go ahead.
Yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking. Now, I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself. So we'll hear everything you have to say about that at trial. Your objections duly noted. But it doesn't change my positions.
Eric Martin insists he has the right to return to the property. The courtroom becomes a mix of frustration, disbelief, and legal precision. The judge carefully notes consequences for violations, and you can sense the suspense. Will Eric follow the law or continue to defy it? This segment perfectly demonstrates the clash between a chaotic defendant and a composed judiciary.
Take a seat
I have a question.
in this blue chair.
Do I have
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit down!
there?
One more time. Sit down. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not an ensleevis, non de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, as a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She is in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR. On the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed that.
Well, your documentation that you file, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I did. I exited the courtroom and asked a police officer, probation
who has
officer
the
to come
indemnity
back.
bond? Where is the bill of particulars?
The
Because
bond
I
is
did not
being,
receive it.
the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
Take her down
For
to
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest. No, this is a false arrest. This is is kidnapping. They're violating my rights, my constitutional rights. I put in,
I thought the Constitution didn't apply to you.
the Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
Amber McHenry turns herself in for minor traffic fines, but she refuses to cooperate, claiming constitutional violations. Despite charges totaling just $300 with no jail time, she is arrested for non-compliance. This part is suspenseful and humorous, showing how absurdity and legal reality collide. The audience experiences both tension and amusement as the court navigates her antics.
Okay, we're going back to the trials now. Frederick Falcon versus James Larry Warnke.
Give this to the judge, sir.
Mr. Falcon, this is your case. So what is it you're asking for the court, Mr.
We purchased the house through property. It's very intimidating. Gun, don't trespass, knocked on the door, left the letter.
Where did you leave it?
On front door.
It says hand delivered. Okay. But you didn't hand it to anyone.
No one refused to answer.
Sir?
No one answered. No one answered.
So you just stuck the notice on the outside of the door?
Stuck it in the door.
In the door. Not on the inside of the door.
Through the crack.
Through the crack.
In the house. Went in the house.
Okay, let me hear from you.
I never did see it,
Okay.
but
What's your opposition to this eviction?
I've got an unrebutted affidavit I sent to the Albert Uresti tax assessor around 2021. He didn't rebut it. So, but an unrebutted affidavit, as far as I know, it's a maxim of law. It stands as the truth of the matter. The truth of the matter is I don't know property taxes because I declared my house private property.
Okay.
And private property is not subject to, only real estate is subject to income, property taxes. So that's what I couldn't understand, how they just went around an unrebutted affidavit like it was nothing.
Okay. So what you have is an issue of title, and I don't have authority to hear any issues of title. Okay? Not within my jurisdiction. You'd have to do that in a different courtroom. Okay. But for today's purposes, you got very lucky because the way you served the notice to vacate doesn't comply with Texas law. You can't just stick it in the door.
Okay.
You have to put it on the inside of the main entry door. You have to look at Texas Property Code,
What do we do?
Section 24.
What do we do if he's not answering or not?
Well, that's what I'm telling you. Either hire an attorney or the notice to vacate was not properly served, and you're gonna have to start over. And so I would suggest we speak with our attorneys about your title issue, if that's gonna be your.
I've got another unrebutted affidavit here called the Executor's Entitlement Land Title, where I own the land
Okay.
under that
Again,
house.
I cannot determine who owns the land. I can only determine who has the superior right to immediate possession. That's the only issue before this court.
Well, hey,
That's the only issue I can address.
let me stop all this then. Let me just give him the house. I've already vacated. I've got another place to live, and I just want to settle this. I'm going to, after the
Lynch has been an attorney. I've known him for 10 years now, at least, right, Mr. Lynch? So, but you think
getting close.
you think you done gone online and found some stuff, and you the trust of the straw man of the sir. You don't even understand the American legal system and how it works. But you gonna make up your own stuff because somebody done told you that this works. Same person who told you it works, it don't work. Then what kills me is y'all do stuff like, oh, and under the UCC and the maritime, y'all start quoting stuff that doesn't mean anything. I had one guy in Atlanta tell me something was under maritime law. I was like, sir, we are not even near the ocean. Maritime law is for the ocean. It's the esoteric foolishness that y'all get because y'all have what? Done your research. No professional. What you over here talking about you the trust. Okay, imagine if you walked into a hospital and they told you needed surgery and you said, oh, no, I'm the trust. I'm not the man. I'm going to do my own surgery because I looked it up online.
I'm not the trust. I'm representing the trust.
No, mister, you don't even know what that means. What I'm saying to you is professionals work for years to learn this, to be able to represent people. You wouldn't walk into a hospital if you had a stab wound or a gunshot wound and say, oh, no, the trust is going to take care of me. I'm going to do it myself because I did some research. I am so sick of y'all thinking that attorneys don't do anything. My mama's an attorney, and one of her clients said to her, well, all you really do is they're trying to pay her. All you really do is talk. I can talk. Yeah, but do you know the right words in the right sequence and the right things to look up to make the talk you do make sense? No, you do not. So if you think you can replace a lawyer, go replace a doctor. Next time you get sick, go break an arm and go set it yourself. Go let the true man set it. Go do that. So if you don't want Mr. Taylor to represent you, that's fine. You are free to represent yourself. I will give you the Ferrata warning as soon as possible. But what I'm telling you is there are problems that come with that because you may be hampered by the fact of what you don't know. The second thing is, don't expect that if it goes wrong for you, that you can then say, oh, well, I didn't have good assistance of counsel, because you are your officer. That's the one where you've decided you do not want the assistance of an attorney. The next case is 2021 CR 04186, traffic violation, which is generally a red light violation. License driving on a suspended or revoked license, count 2. No license, count 3. One of those will merge, so you won't face both of those because of the merger doctrine. So either you would have, if you were convicted, you would face either the driving on suspended or revoked license or the no license, not both. But those are the charges that are currently pending.
Hayward systematically shuts down his pseudo-legal arguments, comparing self-representation to performing surgery on yourself. The commentary is sharp and educational, demonstrating the limits of internet research against formal legal knowledge. The tension builds as Thomas stubbornly refuses, but the court remains calm and authoritative.
Your offense, if you're convicted, the maximum penalty could be up to 12 months in jail, a $5,000 fine, or both per offense. So for each of the offenses, but with merger doctrine, you would have 1, 2, 3 possible 12-month sentences.
And
those could be, or fines. Those could be served concurrently, meaning at the same time, or consecutively, meaning that they would be one after the other. One ends, the other one would start.
All right, I did hear eligible for NOLO. I did hear that come about. So I'll see fit NOLO on the.
Okay, but Mr. Thomas, listen to me. If you're entering a plea of guilty or NOLO, we do a plea right now. If you're entering a plea of not guilty, that means you wish to have a trial at a later date. You can have a jury trial or a bench trial. If you want to do NOLO on your traffic offenses, that's fine. We can do that case now, and you can save the next case for a trial. But if you're entering a plea of NOLO and you want to do that on your traffic offenses, that's fine. We can do that now.
Yes, ma'am. I would like to enter NOLO traffic offenses and not guilty for the obstruction of officer. And by any chance, did that police report show up yet?
We're still pending on the police report, Your Honor.
Okay, so now that you're representing yourself, then you'll have to ask for the discovery so that you can be ready for trial, okay?
So I go to the courthouse?
Yeah, you can do that. On the third floor, the Solicitor General's office, and you want to give them a handwritten note. You don't have to type it up or nothing. You can handwrite it that says, I wish to have the discovery on case 2024 CR 02581. And then put your email address, your phone number, and your full address. And that way they can give it to you or tell you how best to get it.
Okay, and is there any way I could do that without showing up? Because I don't live anywhere like in that area.
You can contact the Solicitor General's office. So you would Google Clayton County Solicitor General, Charles Brooks. And if you call their office, they'll tell you who to contact to get that done.
Yes, ma'am.
All right, Mr. Thomas, did you wish to do the traffic court now? The traffic offenses now?
I believe so, yes, ma'am.
All right, so raise your right hand for me.
I'm not in the jurisdiction of a courthouse, ma'am.
Okay, the law has changed, which under COVID, which allowed us to do hearings by video. So as long as you are on video with me in the virtual courtroom, you're under the jurisdiction and we can do the plea. Did you wish to continue?
No, ma'am, because I'm not under the jurisdiction. I'm in the video because I don't really know how to work this virtual courtroom setup yet. But if I need to exit video to further more speech that I'm not in a jurisdiction, I can exit the video, not the chat itself.
Are you entering a plea of not guilty for this offense also?
For which one?
For the traffic offenses.
No, man, that'll be a NOLO for.
No, we're not doing a NOLO. If you're not willing to do the NOLO by video, then we're not doing the plea right now. You've seen this. You've seen the people come from the jail calendar, and there was even one person in the courtroom. You've been here the whole time, so you've seen how this works. Like I said, I'm not playing your game. Either we do the plea the way everybody else has done it, or
this isn't a game. Like I don't even do court. Like I just happen to get stopped a few times in trucks that aren't mine, so I somehow get entangled with the police and the court system. But this isn't my field. But like I was saying, like it's definitely possible to do a NOLO. I'm just not under your jurisdiction. I'm representing my trust. Like I don't know what I'm supposed to. Like I do my research.
How sovereign citizen tactics fail in structured court settings.